Hello and welcome back to another episode of All Out Nevada, your go-to podcast for insightful glimpses into the Nevada judiciary. I'm your host, Seth Easley, representing the Supreme Court of Nevada Administrative Office of the Courts. In today's episode, we're diving into the Nevada Supreme Court's settlement program. Joining me to discuss this important program is Settlement Judge Ishi Kunin. Ishi has been serving as a settlement judge since the program's inception in 1997. Thank you very much for being here today.
My pleasure. Thank you for having me, Seth.
Okay, so to get this conversation started, for any listeners who may not be familiar, what is the settlement program and how does it fit within the appellate process?
So the settlement program is a mandatory mediation program of appellate cases, which takes place prior to a case going into briefing with the goal that the case is resolved so that it doesn't have to go into briefing, which then takes it all the way through the process of argument, et cetera, before the Supreme Court. Only criminal cases, termination of parental rights cases, and proper person cases are automatically excused from the program.
Okay, so the program was created in 1997. What kind of prompted the creation of the settlement program?
So in or about the fall of 1996, then Chief Justice Cliff Young reached out to an attorney in town who is a settlement judge and has been since the inception, Lance Levitt, who had experience in dispute resolution and had started a program at the federal level about designing a judicial program for the Supreme Court. At that time, there was about 2,500 case backlog. There was no court of appeals at that time. So Lance conducted the initial training for settlement judges in the spring of 1997, and an appellate mediator for the federal court in Georgia was brought in as the lead faculty. At that time, the thought was that a 25 to 30% settlement rate would make the program a success, and I believe that the settlement rate has consistently over the past 28 years been over 50%, averaging about 55%. So I think it's a huge success.
Wow. So it was created to help with the backlog of cases, and it's very interesting that it existed before even the Court of Appeals. So the settlement program, it uses mediations as its dispute resolution method. So how would you describe the role of a settlement judge compared to that of a trial judge or an appellate justice, for example?
So a settlement judge, unlike a trial judge or an appellate justice, has no decision-making authority. Okay. They're not ruling on the case. Their role is more analogous to a mediator's, which is why it's often referred to as a mediation program. The goal is to facilitate a resolution of the matter.
Okay, so no decision-making, they just facilitate a resolution.
Some do it more evaluatively, some do it very facilitatively, but ultimately you're not giving legal advice and you are not making decisions.
Okay, I see. So from your perspective, so the settlement judge facilitates a resolution. How do you approach creating an environment where parties feel comfortable exploring resolution?
A lot of that, of course, depends on the discussions that they may or may not have had with their attorney prior to coming into the program. And no doubt each of us has our own process when first meeting with attorneys and litigants. So generally, I like to bring all of them into the room together initially. We have to sign a court-required confidentiality acknowledgement. I use that as my reason to have everybody in the room. So I only have to go over this document once. When people arrive, they're eager to get out. So it helps me when I can say to them, well, if we can do this all together, we can move it along a little bit faster. I point out to them when they're both in the room, or no matter how many litigants there are, the time and expense that's involved as the case goes through the process. I like them to see that I'm saying the same thing to both sides. So there's no concern I'm favoring an appellant or favoring a respondent. We talk about closure and that it requires compromise on both sides. I tend to keep the process as informal as is professionally possible.
Right.
I tend to let them use I let them use my first name. I ask permission to use their first name and explain how different this process is from when they're in a courtroom and really don't have the opportunity to have say, as they all found out, by the way, because if they're at this level, they've already been through the court process and they either were unsuccessful in a trial where they had the chance to testify, or a decision was made on a motion to dismiss or summary judgment where they never had a chance to present their case. So I try to use it as a place where they can at least tell me about their case. And I know we'll get into this, but that's when we decide, do we keep them together or do we separate them at that point?
That's interesting. You talk about like kind of going over the process with them because so yeah, at this point they've gone through different trials, but they haven't, probably not at least, gone through a mediation like that. And it sounds like you kind of take an approach where you let them know it's kind of like it's them driving the ship.
Right. Versus in a trial, it's not. And for a handful of cases, and maybe more than maybe it's increased over time. They tried mediation before they ever went to trial.
Okay.
That point, these are cases where there really is no desire to settle or compromise because each side has been fed their rights and their attorneys are zealous advocates
Hmm.
and we're going to convince the judge of their position. So why are they going to compromise much? Well, somebody has learned now by the time they get to me that your position wasn't bought or your position had some weaknesses, and hence there are weaknesses to your case. And the other side has learned that they were as convinced as the winning side was that their position was the correct one. And you're taking these risks and weaknesses to now appellate justices.
Yeah, I'm sure at that point, even if they have tried mediation before, their perspective has changed probably.
Yeah.
Could you perhaps just walk us through what a typical mediation would look like as part of the settlement program?
So once we get notice of the case assignment, I reach out to, I'm going to speak solely from the way I practice. It's mandated that we have a pre-mediation case conference. So I reach out and depending on whether there's two attorneys or more, I either set it for a phone conference or I set it for a Zoom. If I've got more than two, I'm not going to know who they are necessarily by voices. And so I'll do the Zoom. In that phone conference, I like to open the discussion regarding a path to settlement. I want to make sure both attorneys understand. Most have been through by now the process. Appellate judges or appellate attorneys are pretty much attorneys that have done enough appellate work that they understand the process. Sometimes we get ones that have never done it before. So I need them to understand what the goals of the program are. You need to be in good faith. You don't have to resolve, but you need to be willing to discuss. And you need to put on a different hat when you're there. It's not the zealous advocate hat. You're still protecting your client, but it's the, hey, this could go different. This could be a case where there's not quite enough to reverse it, but court has so much discretion. So we need to listen with different ears. I like to know if there's other issues outstanding that are outside this appellate issue. So, for example, if the case is a motion to dismiss or summary judgment and it was granted, the underlying case never got heard. So, if you're going to go into the conference solely to decide whether or not you're going to reverse a dismissal or a summary judgment, that's not going to work. Why is the party who has the case all done going to even talk about whether or not it should have been a final decision? But what they might talk about is, again, the risk that the Supreme Court is going to say, we need to go back and hear it on the merits. We need to have some discovery before we can come to this conclusion. We take that, and hopefully with that, we get the parties to at least talk about a resolution while there's still a weighted advantage, obviously, but we can open the door and talk about that. Once I've done that in the phone conference, we set the date for the statements that are due, and we set the date for the actual conference. When we get to the conference, again, I told you earlier how I have everybody together, and at some point we can talk about when you're ready to talk about joint sessions versus private caucuses, how that comes into play. But I get everybody in the room and we move forward. If the case is resolved, we send a status report to the court advising so. We do a stipulation to dismiss so that the appeals case is dismissed. If it's not resolved, we just advise the court that it wasn't resolved and it goes forward.
Okay, so you mentioned joint sessions versus private caucuses. Can you expand on what those are and just how you decide to use either?
So joint sessions are with all the parties. So when I have everybody in the room at the beginning and I'm discussing the confidentiality acknowledgement and the process and where we hope to go, that would be a joint session. A caucus is generally with one side. A caucus can also be when I think it'll be prudent to pull the attorneys without their clients into a separate room and talk to them. So anytime I'm pulling parties out or attorneys out, I'm doing a private caucus. I've had conferences where the entire time is spent together because it's productive. I've had others where after I do my initial spiel, whew, it's time to separate these parties. I can see the eyes, I can see the anger. This will not surprise many, but sometimes the anger is with the one litigant against the other party's attorney, and not even so much as the litigant because of what things have been said to inflame. If I feel that tension, or that we're not being productive, I do caucus. If I think it's helpful to get insight from the attorneys, sometimes they can say things to me they won't say with their client there because they've got to appear like they're the zealous advocate. I will do that.
Okay, that's interesting. So it kind of just it depends on the parties you have before you, that what kind of their history and the context, if it's productive to meet together versus separately.
And it depends on the attorneys. There is
Right.
no, I feel this is time to move to a different level to change the scenery a little bit.
Okay, that's interesting. That makes sense. You mentioned if the mediation doesn't result in settlement, can you kind of expand, or if there's anything else you can add about that? What happens next?
You file your report that says no settlement, and within a period of time, because the settlement judge is copied until the end of the case to follow it along, the court reinstates the briefing schedule. So the court might send all the counsel a note that says they have 30 days within which to submit, well, the opening brief. Transcripts, if they haven't been submitted yet, transcripts are then submitted. So I'm then out of it, and the process moves forward as if there was no program.
I see. Okay. Hi, everyone. I hope you're enjoying this episode of All Out Nevada. We're always striving to bring you valuable education and insights, not just for judicial officers, but for anyone interested in the Nevada judiciary. If you find our content helpful or intriguing, please share your experience with your friends, family, and colleagues. Your support helps us reach a broader audience and ensures more people can benefit from our discussions. Thanks for listening and supporting All Out Nevada. Earlier, you mentioned the program's success rate. So from your perspective, what makes mediation so effective at the appellate level?
Appellate level, I think that I'm really pleased with the result. I think that a lot of it is, again, resting with attorneys to be very honest and open with their clients, and not all are. That won't surprise anybody. To add fire to your client that the district court was completely wrong and we're going to get the Supreme Court to change it. You're not doing the client any good. You're doing a disservice, I believe. Opinions are always wanted, but I don't think you're doing a service when you build it up. So what makes it successful is when the attorneys put on their mediation hats and leave their zealous advocacy hats back in their offices. You're not going to let your client do something that is wrong or is contrary to what the law says, but you need to let clients hear and understand risks, weaknesses, etc. There's a lot of litigants that are ready at that level to be done. And those are the ones you sense pretty quickly. You can see their attorneys still trying to get, the lower court in a family case, for example, or awarded no alimony, and they want to appeal it on the alimony issue. It's discretionary, and those are the things that when I'm doing this, I can explain to the litigant, and I would say without exception, and the attorney will agree. They might think the court was wrong, but they will agree with my assessment of the review process. And so they're tired
Mhm.
and they often want to just move forward. In cases where you've got, for example, an injury and you've got an insurance adjuster on one side, it's nothing out of their pocket.
Right.
So those are going to, if the award was, if they were, if there's zero award and the insurance company doesn't have to pay and the injured party is appealing, how do you get that case resolved? Far more difficult because, depending on the error, by the way, but far more difficult in general because why should the insurance company can hold their money for 2 more years? Even if the appeal gets reversed in 2 years, they've held on to their money that much longer. So you'd need an appellant that was looking more for just some acknowledgement, some nominal compensation to just let this end. And it can be done. I'm
Mhm.
just, again, not 80%, it's not 90%, but I think to get people at that level, even at 52, 55%, I think is a great feat.
Yeah. So you were saying during the program when it was incepted, they were figuring lower. Then
And
okay, that's really interesting. So it's kind of a combination of things, I guess. People, litigants, want to be at this point. They've gone through a long process. They want to see it through. They want to be done with it. That makes sense. And when attorneys successfully kind of change their role to being going away from that zealous advocate to, I'm not even sure how you would describe it, but
most attorneys, they have some idea of where a case really should land.
hmm.
And so that zealous cap isn't going to let them go there, but the mediation hat is going to, for the most part, let them talk about that potential.
I see. Okay. So aside from its effectiveness, for those involved, what are some of the advantages of participating in the settlement program?
Well, and it's some of the same I've talked about, but I know one
Mhm.
of the things I do is I use it as a place to let the litigants truly understand the program. It's not just, hey, we're going to go fight and win this appeal, period. But it's if you're the one that's appealing and you are successful on any point, do you understand that you're going back to the same judge that ruled against you? And you'd be surprised, or maybe not, how many times you get this look of, no, what do you mean? We can't get a new judge? No, unless there's an election, unless there's something intervening that comes into play, you're going back to that same judge who now you've just overturned. And so I think emotionally that has to play a part, and they have to understand that. It gives me the opportunity, if nothing else, to at least be able to make sure both sides understand what happens at the other end of it
Mm.
and what success you may have. If it's a money case and you're the respondent and you want a great deal of money, well, if the respondent is bankruptable, if the respondent has no hard assets, then you're spending a whole lot of time to affirm something that you will likely never collect, but maybe we can get something now absolute. So we can talk about those other kinds of things that, again, attorneys are less likely to talk about because that's not the zealous representation that we're told from the beginning we must have. So I can bring some of those other factors in.
Yeah, at that point, it's been one process, it's been one mindset, and then by the time they get to a settlement judge, they kind of have the opportunity to kind of just change the way they're looking at this process and different paths they can explore.
Correct.
Okay, so kind of switching gears a little bit, what would you say are some of the challenges settlement judges face?
Attorneys are generally the crux of most of the challenges, whether it's because the attorneys themselves are difficult or whether it's because the attorneys have so primed up their clients that there's truly no discussion. When they come into the room feeling that this is a waste of time, Why am I here? I got to pay my attorney to be here. I've already paid my attorney enough. Why am I still here? Um, and they feel wronged. Well, and both of the attorney and the litigant feel wronged by the lower court. They want to prove that the lower court was wrong by getting that appellate ruling that's going to favor them. And sometimes they just need a gentle reminder that the appellate court, and again, because you're trying to get these people to hear you and like you, be comfortable with you, the appellate court might be wrong as well. They might have that same path of knowledge or mindset that your lower court had. And remember, they're all judges. They're all elected officials. This is what they do. So that can be difficult when you've got the attorney who's kind of arguing against, who's not helping you explain that path and reality. Yes, it's the same judge, but I think the judge was biased, so we're going to file for a new judge. Well, how often does that happen? And you have to be very careful because you never want to undermine an attorney in front of their client. So you're walking a very, very fine line there. But that's when a case can become difficult. And by the way, that's when sometimes you pull the plug and say, good luck.
It sounds like, to our point earlier, how it's an opportunity to kind of go in with a different mindset and look at different paths. It's really the challenge is when people go in with the same mindset and just the same idea of how it's going to turn out. So undoubtedly, there are some emotionally charged cases before you. How do you handle cases where emotions are running high or where parties are very far apart in their positions?
Generally, we're going back to caucusing. That's generally when you're going to need to caucus. Having them together is not going to be helpful. If there's a whole lot of motion, it's not unusual that that there's power involved and power on one side, and one side feeling intimidated or in that lesser position. I do a lot of family law, and so we find that a lot. I think it's less about the money. If parties are really far apart on the money side of things, again, unless I'm taking family court out of it, you'd be surprised how many times you can find a middle ground. Now, more in mediation than in an appellate case, because again, let's not lose sight of the fact that we've got a winner and we've got a loser. So maybe that's not as applicable to the appellate cases. I'm thinking of my mediation cases. So I can usually determine in a relatively short period whether continued discussion will result in closing the gap or whether it's just going to raise the emotions. If I find that I just don't think we're going to move somewhere, then I'm going to terminate the conference at that point. But there are different tools that you can apply, and you're kind of the settlement judge is kind of putting on their counselor hat. I never understood the difference between counselors at law and attorneys at law, but if you use the term counselor, you kind of put that on and you find a place. You're not looking at the attorney. You find a place with the litigant where you understand what the process has been. I've been doing this 45 years. I can talk to them about this process. I can tell them personally experiences that I've watched people live through that I've been a part of. And so sometimes you can bring that emotion down when you find some kind of commonality. But if you can't, then you're only going to anger them more by keeping them in that situation, and it's time to let them go.
Right. So have you seen examples of how or where mediation has produced a resolution that courts couldn't have ordered but may have been better for the parties?
Absolutely. And that's the other thing that you began the discussion. If you go into court, the judge is going to either find in favor of the plaintiff, find in favor of the defendant. If it's a family law case, the court is going to equally divide the property. If it's kids, the court's going to do joint physical custody. The court's going to do week on, week off. The court's going to give alternating Christmases, etc. When you're in a mediation or at this level, if those are the issues on appeal, you can explore beyond them. So the piece of artwork that was not gifted to either one, but it was really bought with you in mind because it was so meaningful to you. It reminded you of something. is that's not value. It just is so important to you. But in the division, the other side is going to get it because it's great leverage. You're willing to give up something that they want. You find what's important to you, what's important to you, and let's see if we can resolve in holiday divisions. And in a lot of families, they might celebrate Christmas Eve and not Christmas for whatever reason, or they might not celebrate Easter at all. Court's going to divide them and say, you guys figure it out. In the mediation, we can talk about what we can give up on one end and not feel like we've lost because we've gotten something important to us, and the other side has gotten something that they want. And that you can do in a mediation or in the settlement process. And I think that's critical, getting to the heart of what is it that people want, what is their main objective. And I think that that's what the program, both mediation and the appellate program, can do. The other thing that can happen is the appeal might be on a matter that's the guardianship case, for example. And I had one like this, and so I'm using it. And it's a very specific issue that's probably resolvable on appeal, but it's still going to leave all these people fighting because there's a tangential probate case, or there's another guardianship case on the other side with different components to it. And so the court sitting is only going to look at these facts in front of them and rule on that particular fact. And so you're still not done with litigation. So what's the motivation? I got to litigate anyway. So it's part of my pre-mediation conference with people is tell me everything else outside of the circle so I can bring it in. Because if we're going to resolve, let's resolve it all. And that's a wonderful feeling when you're able to do that.
I can see how when you're faced with something, especially if you're hearing something family related, it's like, what are you really fighting about? And if we can resolve it all here, you're not still fighting about it or disputing after this process is over. That's so interesting. It just allows you to explore a lot of nuance.
It does. So maybe in a family case, it's on appeal because the court did a custody award that you didn't agree with, but the other side gets upset then, and so they file some kind of slander or libel lawsuit because what you said wrecked their business, whatever it be. Things are exaggerated tremendously. If you can bring that into the table and talk about how you really don't have a lot of merit in this case you're filing, it's only inflaming the situation. Can we come to a place where all of this goes away and you guys can just move forward and stop paying these attorneys who have other cases and are making a living anyway? And sometimes that works.
That's so interesting. I love that. So I think this kind of touches on what you were saying before, but how people can leave that process and feel like it's done and no need to fight anymore. What do you find most rewarding about serving as a settlement judge? And do you have any success stories that you could share from your time with the program?
For me, most rewarding is I love resolution. And I think it's rare when resolution is not achievable. Relocation cases where one parent wants to move out of state against the other parent's wishes. I think those should probably be removed from the program. They're not going to settle. Uh, Awards of primary physical custody to one parent are likely not going to be resolved because it's kind of like the insurance company that doesn't have to pay any money. They've bought themselves a year and a half, 2 years of primary physical custody. So their worst case scenario is in 2 years, the judge will fix it and I'll lose primary and have 50-50, but I've just bought myself the age of 4 and 5, or I've just, there's nothing you can really say that's going to get that resolved. But all other cases, I just think there's a path if everybody is willing to invest themselves in looking for that path. I mean, some of my favorite store, for example, when I can take cases that have tangential cases that aren't there, but I can do global settlements, those make me feel like we've really achieved something because now everybody is done with litigation. If there's another party involved, but not in this particular case on appeal, I will reach out to see if that party will participate so that we can help resolve their lower court case before it gets to this level. And it's up to the parties, but I feel those successes they make me smile. I'm just glad when I can get people out of litigation. I did this long enough. I practiced law long enough that the old adage, you win some, you should have lost, you lose some, you should have won. And it's so true. So why are you rolling the dice? Let's take the known. Let's get to where we need to be and move on.
That's awesome. I love that. Lastly, but certainly not least, before I wrap up this episode, what do you hope attorneys and the public take away about the value of mediation and the settlement program?
That they don't look at it as a waste of time or an additional place for attorneys to charge while they want to get to the appeal. I hope they understand that this program is there not to a stone in the way of their progress, but rather to hopefully give them closure and get them out of a process where, again, there's a crapshoot involved to some degree. I think that if they can understand that resolution compromise serves them, it's not about the other side, serves them financially and emotionally, then that's something I would love them to take away. That it's healthier when you're not caught up in a legal situation. Hard to find a case, and there are those where you've just got to go to court when it's I've seen freedom of speech press cases with the newspapers here in town. I've seen those cases with unions. They need a Supreme Court ruling, but just most cases are just people who don't like each other or people who have very strong feelings on one side or the other, or their job is to pay out as little as possible, and if nothing and the other side wants, generally you can reach resolution, and at least it's a good effort. I think if they can trust that the Supreme Court settlement judges will not keep you beyond what they feel is productive. I'm probably going to make you come. I'm probably going to be a difficult one to talk out of doing it in the first instance. But when I get you there, because again, remember in that first instance, I'm just talking to attorneys. I don't know I need to talk to the clients. And once I get a feeling that they're just as unhappy, then I'm going to let them go.
Awesome. Well, Ishi, I really appreciate you taking the time to meet with me today and to talk about the important work the settlement program does and the role of settlement judges. So thank you very much. I appreciate it.
Sure. Thank you.
A heartfelt appreciation to our guest and to everyone who has tuned into this podcast. Before we wrap up, here are a couple of quick important reminders. For continuing legal education credit, be sure to complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. If you have any questions, topic suggestions, or comments, we welcome your input. You can email us at jepodcast@nvcourts.nv.gov or submit your topic ideas to the topic suggestion form linked in the episode description. We value and look forward to hearing from our listeners. Stay tuned for more episodes of All Out Nevada. This is Seth Easley signing off. Take care, Nevada.